Hello, my name is Loveleen Bhular and I'll be making a presentation on the topic Laws relating to air pollution in India. Before we start, a brief background about air pollution. Commonly, air pollution is defined as the presence of a pollutant in the air or in the atmosphere. There are broadly two main types of air pollution: indoor air pollution and outdoor air pollution. Now, the causes of indoor air pollution include smoking, inefficient burning of inferior fuels, and poor ventilation, whereas the causes of outdoor air pollution include vehicles, industries, power plants, mining activities, construction activities, firecrackers, cigarette smoking, and crop burning, etc. Air pollution is an issue which requires urgent regulation, and the need for regulation is borne by the fact that a recent report of the Central Pollution Control Board from the year 2010 has said that the particulate matter in the air of 180 Indian cities was 6 times higher than the standards laid down by the World Health Organization. An even more recent report from this year, which was released by the Yale Environmental Performance Index, has ranked India as number 174 out of 178 countries in terms of air pollution. Clearly, it's a very serious issue requiring urgent attention. The objective of this particular module is to introduce you to the legal framework concerning air pollution in India. We'll be looking at the features of the Constitution of India, the Air Prevention and Control of Pollution Act 1981, a specific law on air pollution, the Environment Protection Act of 1986, which is the umbrella environmental legislation in India, as well as the Environment Protection Rules of 1986 framed under the Environment Protection Act. And also we'll be looking at some of the important judicial decisions, primarily from the Supreme Court of India, dealing with specific aspects of air pollution. Insofar as the Constitution of India is concerned, there is no specific provision on environmental pollution generally or air pollution specifically. However, the Supreme Court of India has broadly interpreted Article 21 of the Constitution, which guarantees the fundamental right to life, to include the right to enjoyment of pollution-free air. This was done in the case of Subhash Kumar versus State of Bihar, a decision from the year 1990. The specific legislation on air pollution in India is the Air Prevention and Control of Pollution Act 1981. Now, this law is basically a consequence of domestic implementation of a decision which was taken in 1972 at the historic Stockholm Conference, also known as the United Nations Conference on the Human Environment. And the decision taken at this conference was to take appropriate measures to preserve air quality and to control air pollution. Now, the Ministry of Environment and Forests at the central government level exercised its power vested in it by Article 253 of the Constitution in order to make this law implementing a decision which was taken at an international conference, namely the Stockholm Conference. The primary objective of the Air Act is to prevent, control, and abate air pollution. The term air pollution has been defined in the Air Act as the presence in the atmosphere of any air pollutant, and the term air pollutant has been defined in the Act as any solid, liquid or gaseous substance, including noise, present in the atmosphere in such concentration as may or tend to be injurious to human beings or other living creatures or plants or property or environment. The responsible agencies under the Air Act are the same as under the Water Prevention and Control of Pollution Act 1974, namely the Central Pollution Control Board at the central level and State Pollution Control Boards at the state level. At the central level, the Central Pollution Control Board, or the CPCB, is responsible for improving air quality and for preventing, controlling or abating air pollution. For this purpose, the CPCB is responsible for laying down air quality standards, and these have been laid down in the form of the National Ambient Air Quality Standards 2009, which deal with areas such as industries, residential areas, rural and other areas, as well as ecologically sensitive areas. At the state level, the State Pollution Control Board is responsible for discharging a number of functions which affect air pollution. These include laying down, in consultation with the Central Pollution Control Board and having regard to the air quality standards laid down by the CPCB, standards for emission of air pollutants from industrial plants and automobiles into the atmosphere, or discharge of any air pollutant into the atmosphere from any other source which is not a ship or an aircraft, because ships and aircrafts are dealt with under separate laws. The other function that the SPCB is required to perform under the Air Act is to advise state government on the suitability of any premises or location for carrying on any industry which is likely to cause air pollution. Under the Air Act, the state government has also been given the power to notify certain parts of the state as air pollution control area or areas. This power has to be exercised by the state government in consultation with the State Pollution Control Board. Now, once an area has been designated as an air pollution control area, certain activities are prohibited in this area. For example, the use of non-approved fuel or non-approved appliance and or burning of any material which is not a fuel. Both of these terms, approved fuel as well as approved appliance, have been defined under the Air Act. Now, the reason for this prohibition is if such a non-approved fuel or non-approved appliance may cause or is likely to cause air pollution. The decision to prohibit such fuels or appliances is to be taken by the state government after consulting with the State Pollution Control Board. The other important legislation from the point of view of air pollution is the Environment Protection Act of 1986, where the definition of the term environment includes air. The definition of environmental pollution means the presence in the environment of any environmental pollutant, and the term environmental pollutant means any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to the environment. Under the Environment Protection Act 1986, the Ministry of Environment and Forests has been given a number of powers, one of which is to take measures to protect and improve the environment. Under the exercise of this power, the MOEF can lay down emission or discharge standards for air pollutants. The MOEF also has the power to make rules to regulate air pollution. For example, laying down air quality standards for various areas and purposes, and laying down maximum allowable limits of concentration of air pollutants for different areas. Again, as in the case of the relationship between the Environment Protection Act and the Water Act, in this case as well, the standards under the Environment Protection Act and rules will be placed in higher capacity over the standards under the Air Act. The other relevant source of legal provisions are the provisions relating to public nuisance. Such provisions are found in tort law under Section 268 of the Indian Penal Code, Section 133 of the Code of Criminal Procedure, as well as Section 91 of the Civil Procedure Code. However, the length and expense of litigation which is involved in proceeding with such public nuisance claim and the difficulty of establishing liability has usually prevented individuals and groups from pursuing this form of remedy. Now, moving on to some specific forms of air pollution. One of the more common forms of air pollution is industrial pollution. Now, the Air Act states that an industrial plant in an air pollution control area requires previous consent to establish from the State Pollution Control Board. Also, such an industrial plant, once it starts operating, is not permitted to discharge any air pollutant in excess of the standards laid down by the State Pollution Control Board under the Air Act. Otherwise, such a plant would be subject to penalty which takes the form of imprisonment as well as fine. Also, under the Air Act, a person may be restrained from emitting an air pollutant. Now, as in the case of the Water Act, the State Pollution Control Board does not have the power to impose penalty or restrain a potential air polluter unilaterally. In other words, the State Pollution Control Board has to file a complaint or an application before a court of law, and the court of law will take cognizance of such a complaint or application from the State Pollution Control Board. However, the State Pollution Control Board, as in the case of the Water Act, does possess the power to direct closure, prohibition or regulation of any industry, operation or process, or to stop or regulate supply of electricity, water or any other service. A very important case from the Supreme Court of India dealing with industrial pollution is the Taj trapezium case from the year 1997, also known as MC Mehta versus Union of India and others. This case concerned the effects of air pollution on the Taj Mahal in Agra. According to the petitioner, the sources of air pollution in this particular case were foundries, chemical hazardous industries and the Mathura refinery, brick kilns, vehicular traffic and generator sets that were being extensively used in the area surrounding the Taj. The court applied the precautionary principle, which has been discussed in detail in the module on principles of environmental law, and which states that environmental measures must anticipate, prevent and attack the causes of environmental degradation. According to the court, the burden of proof in this particular case was on the coke or coal consuming industry to show that its operations are environmentally benign. According to the court, the emissions generated by these industries are air pollutants and they have a damaging effect on the Taj and the people living in the TTZ or the Taj trapezium zone. According to the court, further, atmospheric pollution in the TTZ has to be eliminated at any cost. And the reason this case is very interesting is because the court goes on to say that not even 1% chance can be taken when human life and the preservation of a prestigious monument is involved. In other words, the court is prioritizing human life and the preservation of a monument such as the Taj Mahal over industrial activities in the area. The court then directed the identified industries to either change over to natural gas as an industrial fuel, and the industries which could not obtain a natural gas connection were asked to stop functioning with the aid of coke or coal in the TTZ and to relocate away from this particular area. Moving on to another important source of air pollution, which is vehicular pollution. Under the Air Act, the State Pollution Control Board has laid down standards for emission of air pollutants from automobiles in consultation with the Central Pollution Control Board. These standards, known as the Standards for Emissions of Smoke, Vapor, etc. from Motor Vehicles, require the state government to give necessary instructions to the Vehicle Registration Authority under the Motor Vehicles Act of 1989 as well. Under the Motor Vehicles Act, certain powers have been given to the central government. One is to prescribe emission standards for vehicles and to frame rules to regulate the construction, equipment and maintenance of motor vehicles in relation to emission of smoke, visible vapor, sparks, ashes, grit or oil, and in case of contravention of these provisions, the punishment is a fine. There are also provisions of the Central Motor Vehicle Rules of 1989 which are relevant to air pollution. The first one is setting of nationwide emission levels for old and new diesel and petrol engine vehicles. The manufacturer is required to certify conformance to these particular standards, and these standards are identical to the emission standards for motor vehicles under the Environment Protection Rules 1989. Under the Central Motor Vehicles Rules of 1989, you are also required to obtain a Pollution Under Control Certificate for vehicles, also known as a PUC. The enforcement of all of these vehicular pollution related provisions is the responsibility of the state or the regional transport authority appointed under the Motor Vehicles Act. The Supreme Court has issued a large number of orders relating to air pollution in general and vehicular pollution specifically. And this is often quoted as one of the major differences between the implementation of the Water Act and the Air Act, where the Water Act implementation has suffered seriously whereas the implementation of the Air Act and the provisions there has been taken on quite seriously by the Supreme Court of India. For example, we have orders from the Supreme Court relating to mandatory use of catalytic converters for specific type of vehicles, introduction and use of unleaded petrol for motor vehicles, conversion of vehicles from the use of petrol, diesel to CNG or compressed natural gas, setting up of a time frame for the gradual phasing out and banning of old commercial or transport vehicles from the roads of Delhi, also conformity of certain vehicles depending upon their date of registration in the National Capital Region to Euro 1 and Euro 2 norms. More recently, earlier this year, the Supreme Court has issued notices to the central government as well as the state governments of Delhi, Haryana, Rajasthan and Uttar Pradesh on certain actions. These include uniform Bharat Stage 4 standards nationwide and tighter emission standards, effective gap between diesel and CNG prices, lower taxes on buses, uniform vehicle tax measures across the National Capital Region or the NCR, and effective increase in parking pricing and enforcement to cut car usage. The third major source of air pollution is noise pollution, and the sources of noise pollution include microphones and loudspeakers used in religious ceremonies and public meetings, electric and air horns used in buses and trucks, as well as fireworks. As previously mentioned, noise is recognized as one of the pollutants under the Air Act. It is also recognized as an environmental pollutant under the Environment Protection Act of 1986. There are also other relevant laws for noise pollution control, and these include local municipal laws as well as state-level police laws. Under the Environment Protection Rules of 1986, standards for emission or discharge of environmental pollutants from industries, operations or processes include standards with respect to noise pollution, and these include noise level standards for coal mines, noise limits for automobiles, noise limits for domestic appliances and construction equipment at the manufacturing stage, as well as noise limits for generator sets run with petrol or kerosene or diesel. More specifically, a noise pollution regulation and control rules were framed in the year 2000 and amended in the year 2010. Framed by the Ministry of Environment and Forests, these rules prescribe the maximum permissible limits for noise in different areas. They lay down ambient air quality standards in respect of noise for industrial areas, commercial areas, residential areas or silence areas or zones. In these areas, use of loudspeakers or public address system and sound producing instruments is subject to written permission. The rules also prescribe permissible noise level at the boundary of a public place or a private place where a noise source is used. They prohibit the use of horns, sound emitting construction equipment and bursting of firecrackers in silence zones or during night time, and night time is defined as the period between 10 p.m. and 6 a.m. and this rule applies to residential areas, and the violation of any of these rules is punishable under the Environment Protection Act 1986. We also have a number of judicial decisions on noise pollution, both from the Supreme Court of India as well as High Courts. I would like to draw your attention to a decision of the Supreme Court from the year 2005, and the name of the case is In Re Noise Pollution, Implementation of Laws for Restricting Use of Loudspeakers and High Volume Producing Sound Systems with Forum Prevention of Environment and Sound Pollution versus Union of India. The Supreme Court observed, and I quote, "Anyone who wishes to live with peace, comfort and quiet within his house has a right to prevent the noise as pollutant reaching him. No one can claim a right to create noise even in his own premises which would travel beyond his precincts and cause nuisance to neighbors and others. If anyone increases his volume of speech, and that too with the assistance of artificial devices, so as to compulsorily expose unwilling persons to hear a noise raised to unpleasant and obnoxious levels, then the person speaking is violating the right of others to a peaceful, comfortable and pollution-free life guaranteed by Article 21 of the Constitution of India. The Supreme Court then went on to issue a number of directions in this case. It first divided firecrackers into two categories, light-emitting and sound-emitting firecrackers. It then went on to impose a complete ban on bursting sound-emitting firecrackers and the beating of drums or tom-toms or the flow of trumpet or the beat or sound of any instrument, the use of any sound amplifier between 10 p.m. and 6 a.m., the period defined as night time. The Supreme Court also directed the state government to seize loudspeakers and amplifiers making noise beyond the permissible limit, to specify ambient air quality standards in different areas, as well as to add a chapter in textbooks regarding ill effects of noise pollution. Another important source of air pollution, which receives less attention sometimes, is cigarette smoking. There are two legislation which are relevant in this context. The first is the Cigarette and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution Act of 2003, and we have the more recent Prohibition of Smoking in Public Places rules of 2008. What this act and the rules do is prohibit smoking in public places and open places that are visited by the public. Both of these terms have been defined. The term public place is defined as a place where the public has access, and this includes workplaces, shopping malls and cinema halls. Open places have been defined to include open auditoriums, stadiums, railway stations and bus stops. However, certain areas have been exempted from the application of this act and the rules, and these include hotels with more than 30 rooms, restaurants with more than 30 seats and airports which are allowed to have a separate smoking area or space. More recently, specifically around Delhi, the problem of open burning of waste has presented itself in the context of burning of crops by farmers. This open burning of waste, particularly illegal burning of different types of waste, can be the burning of municipal solid waste, plastic waste, hospital waste, etc. Now, different types of waste are governed by different rules which have been framed by the Ministry of Environment and Forests in exercise of the power conferred on it by the Environment Protection Act 1986. For example, we have the municipal solid waste rules, we have the hazardous waste rules, etc. Insofar as plastic waste is concerned, there is the Plastic Waste Management and Handling Rules of 2011, which specifically prohibit open burning of plastic waste. Clearly, the provisions of these rules are being blatantly violated because there are many instances of plastic waste being burnt openly in cities and villages across the country. Recently, a petition has been filed alleging the illegal burning of plastic, rubber and related waste, which releases deadly dioxins and furans in various villages in North and Northwest Delhi. After hearing this petition, the National Green Tribunal has imposed a nationwide ban on unregulated open burning of plastic, rubber or such other articles. Insofar as municipal solid waste is concerned, although the current municipal solid waste rules do not specifically prohibit open burning of waste, we do have the draft Municipal Solid Waste Management and Handling Rules 2013, which prohibit open burning of municipal solid waste. To summarize, the objective of this presentation on the module Laws Relating to Air Pollution was to familiarize you with the legal framework existing in India. As discussed, this comprises the Constitution of India, where although there is no specific provision, the Supreme Court of India has broadly interpreted Article 21 of the Constitution, which guarantees the fundamental right to life, to include the right to pollution-free air. We then went on to look at a specific legislation, the Air Prevention and Control of Pollution Act 1981, and general legislation, the Environment Protection Act and the rules framed thereunder, both from the year 1986, which grant considerable powers to the Ministry of Environment and Forests in the case of the Environment Protection Act, and the State Pollution Control Board and the Central Pollution Control Board in the case of the Air Act to lay down standards and rules for managing different kinds of sources of air pollution. We also discuss that the implementation of the Air Act has been more effective than that of the Water Prevention and Control of Pollution Act 1974, which has suffered from serious challenges. Further, we discuss some specific instances of air pollution, namely industrial pollution, vehicular pollution, noise pollution, pollution caused by cigarette smoking, as well as due to open burning of waste. The presentation drew your attention to an important case of the Supreme Court, the Taj Trapezium case, which concerned air pollution resulting in damage to the Taj Mahal in Agra, as a result of which the Supreme Court specifically applied the precautionary principle and held that the protection of human life and an important monument such as the Taj Mahal had to be given precedence over the industries operating in the area. In this case, the court firstly asked industries using coke or coal to switch to natural gas, and for industries that were unable to make the switch, they were asked to close and to relocate. This is a very important decision because it highlights an instance where the balancing between economic development and environmental protection was favoring the environment. Subsequent decisions have taken a different view of the idea of sustainable development, which has been discussed in the module on principles of environmental law. We concluded the presentation with a discussion on the open burning of waste, which presents a very serious problem in urban areas specifically, and more in rural areas as we see plastic waste being generated in larger quantities. Thank you.